All right. Hi, everyone. Hello. How's everyone doing? Good? All right. Very good. I hope everyone had a nice weekend. I apologize. I forgot my jacket at home, and I don't like wearing a tie without a jacket, so I'll do my best. Seriously, I never liked the tie without a jacket. I've never gotten that. But I forgot my jacket at home because I put on a real jacket today, and I was a little confused. Once I wore sneakers, so I usually walk my dog in my suit before I come to class, and I forgot to change the shoes. So fortunately, I have real shoes on today, but it's happened before. All right, let's see. Any questions? Anything in your mind? Anything in your questions from Noel Canning? Yes, sir.
On the last case we read, the dissent, Scalia says that.
For today or from last week?
I guess
We'll cover that today.
Okay.
When we get to the case, ask me, okay? Any questions from last week, from last class? I promise we'll cover that case at great length. Anything in your minds? Rebecca told me none of you went to the Langdell. She said it went very well. About a third of you were there, which is actually roughly half, which is quite good. So hopefully you continue to go, and you learn from her, and I think it'll be very worthwhile. Okay? All right, so today our focus is on the removal power. So let's focus on what we did last week versus this week. Last class, we focused on the appointment power. And we said, generally speaking, the president needs the advice and consent of the Senate to appoint officers to the United States. And the reason for this, we said, was because of the separation of powers in the Constitution. The president can't have whoever he wants in charge of his executive officers. He needs basically the Senate's approval. There are some narrow exceptions to this. For example, the recess appointment power. And we discussed at great length when that could be used. And ultimately, the court said this can only be used during some sort of break in the Congress of a sufficient length. What that length is, we don't exactly know, but Justice Breyer says probably more than 10 days. We don't know the exact length. It's probably somewhere more than 10 days, says Justice Breyer. Justice Scalia, we should not be surprised, had a vociferous concurring opinion, which was in fact the dissent. And Scalia said, no, 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 no. The Constitution spells out very clearly when you can make recess appointments. It's between the sessions of the Congress. And that only arises for people who are dead during that time period. So you cannot fill any pre-existing vacancies. So we see already this tension on the court where some justices are willing to give a kind of flexible, maybe called functional approach to the appointment power. This exact question has been going on with the removal power for almost 225 years. And what you'll see in the three cases we do today, which is kind of like a trilogy, almost as bad as Back to the Future. No, Back to the Future is good. Star Wars is bad, right? Second, the first trilogy, the first three. Anyway, my opinion. Awesome. We have these three cases which sketch out at some length how to understand the removal power. As you were preparing for class today, you probably read the first case like, all right, I got this, right? This is really easy. The president can remove whoever he wants. Then you read the second case like, well, maybe he can only remove people who are purely executive and not people who are quasi-judicial, quasi-legislative. And then you read the third case like, oh, screw it, I have no idea, right? These three cases are not very easy to reconcile. And they're taught in this chronology for a very specific reason. Because often the Supreme Court grapples with its own doctrine. They don't like overturning cases. They never like overturning cases. So instead, they either read a previous case broadly or narrowly. And what you'll see from Myers to Humphreys to Morrison is not a straight path, but this curvy, windy road where they try to figure out what extent the president can remove people from office. So my strategy for teaching this is to start, as we always do, with the text. Then we can do some of the history from the early Congress. Then we can look at things like the Federalists. We'll look at things like Marbury versus Madison. Then we'll look at practice. Practice, right? Practice. We'll look at practice of what's actually been done. And then, only then, do we get to the issue of Myers and whether he can be removed as a postmaster from Oregon, which you may not think is a very important or consequential position, but at the time it was very significant. Okay? All right, so any questions before we get started? No? Is that a hand or are you just scratching? Okay. All right, where did I finish last time? Oh, thank you, sir, honestly. That's Wade?
Yes.
All right, Wade. So let's start only with the text of the Constitution, right? What does the Constitution, what does the Constitution say? If you want to look in your books, it's on page 27, right? Wait, what does the Constitution say about the president's power to appoint people? This is what we did last week. What's the general rule when the president wants to appoint people? Good. So we look here in Article 2, Section 2. I'm sorry, it's page 28, my mistake. Or actually, 30, sorry, page 30. If we look at Article 2, Section 2, and it says right up here, he shall nominate by and with the advice and consent, ambassadors, officials, and for our purposes, officers of the United States. Okay? So we know at the outset, for the president to appoint anyone, he needs consent of the Senate. Okay? Now, last week we didn't really read past that first part. Wait, please read for me. Everything comes after the colon, the but part.
But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law or in the heads of the departments.
Whoa. So we didn't read this part last time because it wasn't very important. But Wade, what does this mean? What does this last clause mean?
As for any,
Who are these inferior officers? Who are these people?
maybe like a postmaster.
Maybe. Who are, let's say, Madison, right? Madison. Who are these inferior officers, does the Constitution say? Yeah, we're only looking at the text now. No postmasters yet. Okay, so let's look at another provision which you may have looked at before, Madison. So Article 2, Section 2, it's right up here, right? Constitution says the president may require the opinion in writing of the principal officer in each of his departments. So that basically means if the president so wishes, he can ask for a written opinion from, say, Secretary of the Treasury or the Secretary of War, whatever, right? Madison, how do you think we should understand if in this section speaks of inferior officers and here it speaks of principal officers? How do you think we should understand those two different positions? That's a good answer. We don't have a good answer. That's a good one, right? We don't have the right answer. So the Constitution mentions two different types of officers, right? You have these principal officers. These are someone, I guess, of importance who can give written opinions to the president on matters of some sort of significance. And then you have inferior officers, right? We don't know who they are, but they're not quite as important. They do something less. So Madison says, I think that's reasonable. Well, you're either principal or you're inferior. That's a reasonable guess. Let's see. Is that Daniel? Daniel, one other clue, though, we have about why an inferior officer is not important is how they're appointed. What's the process, Daniel, by which the inferior officers are appointed? There's actually a couple different approaches.
One of them is the vice.
No. We're in the but, right? How are the inferior officers appointed, Daniel?
They're just appointed.
No. They're not just appointed. Read it.
Are we in section 3?
Right here. You see this?
The contract.
Then look in your Constitution. It's there also.
We're section 2. Right?
Yes. It's right there on page 30.
Okay. You shall have the power by and with the advice.
No, keep reading at the end. But,
But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the
What does that mean? What does it mean for the Congress by law to vest the appointment of such inferior officers as they think proper in the president alone, the courts of law, or in the heads of departments? What does that mean?
I would say that it would be the president of law. The fact that it says that the Congress may by law vest the appointment as they think proper in the president alone. And so the Congress may give the president.
Well, there are commas there, but that's the general idea. Okay? For these inferior officers, these low-level positions, right? The Constitution says you don't need the advice and consent. But Congress is involved in one very important way, right? Elise? No, that's Ryan. How is Congress involved with respect to the inferior officers? What's Congress's role? It's right there.
They made by law. That's the appointment.
What does it mean for Congress to vest by law? What does that mean?
By law, vest the appointment.
Yeah, what does that mean?
I mean, like they have the ability, or they have the ability to give the president power.
How does Congress give the president power? What's the only mechanism they can do that with? No. How does Congress give the president power? What does Congress do? What's the only thing Congress can do? Who else rocks? What does Congress do? Come on.
I mean, pass bills.
Laws. Yes.
Yeah.
Congress passes laws. So Congress, by a law, by writing a statute, by writing a bill, can give the power of appointment of inferior officers. Right? So Congress passed a statute saying, okay, you know what? If you want to appoint a deputy postmaster in Jane, Wisconsin, right? The president can do so alone. Or the head of a department. So say the postmaster general, the number one postmaster in the country. Congress can give him the power to appoint people. Has anyone ever been a federal employee? Okay. Did you receive your commissions from the president? The answer is no. Right. How were you hired? Do you know how you were hired?
Bureaucrat at the State Department.
Yes. And who's that bureaucrat's boss?
It went up all the way up to Secretary Rice at the time.
Yes. So anyone who's ever been working in any federal agency, you are inferior. I don't mean to put that lightly, but you are an inferior officer. And your hiring did not go through the United States Senate. It may have, but I don't think it did. Your hiring was from the head of the department. So you work at the State Department, the Secretary of State, delegated to her subordinate, and all the way down the line to the person who hired you. How is that possible? How come Jason got hired without the Senate approving his hiring? Because the Congress gave to the Secretary of State, the head of the department, the power to hire these inferior officers. Everyone with me so far? One interesting bit is the courts of law. So has anyone ever know anyone who clerked for a federal judge or had a law clerk? Right? Was your friend confirmed by the Senate? No. The courts are given the power to hire inferior officers. So any federal employee that you know who's not like a political whatever came to the government through this clause. Right? So Congress understood that, look, there are going to be a lot of low-level, middling employees who aren't very important in the grand scheme of things, and the Senate doesn't need to be involved. Okay? But, right? But, William, who gets to decide whether a position is inferior, that, the person can be hired without the Senate's permission, or a high-level principal officer? Who gets to make the decision?
The Supreme Court?
Wrong.
No, it's not.
Read it. Read. Who vests laws? No. Same answer as before. Who vests power?
Congress. Legislature.
Why?
Because they make laws.
Yes. Do not forget this. I know it's such a trivial point, but when I ask who gives power to the president here, the answer is Congress. Right? Because who created, I'll ask you a follow-up, William, who created the positions of Postmaster General? Who creates these positions?
Congress.
Yes, Congress. Is there anything in the Constitution about postmasters? The only positions that are in the Constitution are President and Vice President and maybe Chief Justice of the United States, depending on how you count, right? Every single federal official, even Jason's job and your job and your job, all of your positions were created by Congress. Okay? So, Brett, so we understand that Congress has the power to create these different offices, right? And we also know that Congress sets salaries for these offices, right? They decide how much Jason gets paid for a State Department position, right? Can Congress terminate a position? Can Congress just say, you know what? We don't want to fund Jason's position anymore. He's not doing a very good job. Cut it out.
Yes.
Yes. This may, I mean, there are various civil servant protections and union things and whatever else, maybe a protection, but generally speaking, from a constitutional angle, Congress has the power to create an office. They have the power to destroy an office. With the exception of federal judges. Recall that federal judges have lifetime tenure and a guaranteed salary, right? Jason has neither. I don't mean to pick on him, but he was a federal employee, so I will pick on him. Okay? Everyone with me so far? So we know from the text of the Constitution, right, that Congress has no problem eliminating positions. So, Austin, no, Rob, could Congress decide, you know what, we don't want to fund the Secretary of Defense position anymore. We don't like how he's doing. We're just going to just cut ass funding. Do they do that? Defund the Secretary of Defense position? They could. It would be a mess. It would be very unpopular. The president would complain. Let's see. This one's going to be a tough one. Is that Austin? There's people not are in the right seats. Okay, Luke. That's fine. Luke, what would the president say? What would his argument be if Congress decided to defund the Secretary of Defense? What do you think the president would say? What do you think his objection would be?
I don't think they have one.
Oh, I'm sure he'd scream and complain. What do you think? What do you think he would say? What do you think he'd say, Luke? What would the nature of his argument be? What?
He's not appointed by the president.
No, the Secretary of Defense is appointed by the president. What do you think?
It could weaken his ability as commander-in-chief.
Excellent, right? The Constitution says the president's the commander-in-chief. He's like, listen, I'm the commander-in-chief. I have a duty to keep this nation safe. If you take away my Secretary of Defense, right, I can't do my job. Now, this is the bonus question. What provision of the Constitution, other than the commander-in-chief clause, does he cite? Yeah?
That he has a constitutional obligation to take care of the
Exactly. 100%. Yes. The president has a constitutional imperative right here, Article 2, Section 3, to take care that the laws be faithfully executed. Sarah, what does that mean to take care of the laws and faithfully executed in this context? What does he have to do? What's the president's obligation?
I mean, he's the chief law enforcement officer, so if they took away his Secretary of Defense, he wouldn't be able to control the 2 million people he oversees.
Yes. Yes.
There's an immunity.
Exactly. So we've discussed the take care clause in some of its modern context, right? Of whether the president cannot enforce the laws. This is a fairly recent problem. Traditionally, what the take care clause mean? Listen, I am the president. I need to execute the laws. If you don't give me a Secretary of Defense to oversee my military, I can't do my job effectively. For the Congress to get rid of my Secretary of Defense would really screw up my job as Commander-in-Chief. Right? So even though Congress could, in theory, defund the Secretary of Defense position, I think there's certain separation of powers issues in doing so. And here we get to the kind of notion of what separation of powers are. We're not just talking about clauses in the Constitution. It's the relationship between the branches. that if Congress does something that really screws up the president's power, there's a good chance it's unconstitutional. And there's no bright line rule. That's why I have to go through case by case. So let me ask then a follow-up question. Lauren? Lauren, let's say instead of the Congress defunding the Secretary of Defense, right? Let's say, I don't know. Let's say that President Bush, George Bush, had appointed Donald Rumsfeld as Secretary of Defense. And Rumsfeld refused to retire. And he was very hawkish, very big on war. And then President Obama comes into office. He says, Mr. Rumsfeld, I demand that you resign. I want to take the Iraq war in a different direction. I want to do this and that. And Rumsfeld says, no, it's not going to happen. Okay? So then President Obama says, well, you're fired. And Rumsfeld says, no, you can't remove me. What do you think the President Obama would say in that case? How do you think he'd feel? How do you think he would react to that? Let's put that aside for a second. What do you think the president would say in a letter firing Rumsfeld? Why do you think you'd want to fire him?
He doesn't agree with his policy.
Exactly. Yes, that's the key. He's like, listen, I am elected president of the United States by all the people, by all 50 states, or 57 as it may be, right? I have a duty to faithfully execute the laws. I can't do my constitutional duty with this jerk sitting in the Pentagon, right? I don't agree with him. He wants to go blow up all these other countries, right? I don't want to do that quite yet. So you have to think, I can't execute my duties under these circumstances. And I think he'll be exactly right in those cases. So only based on the text, and we've not even gone to any case law or anything else, we see that the Constitution is silent on the removal power, right? The Constitution doesn't really say anything about the removal power. All it says is that the president needs to have the advice and consent to appoint some officers. Maybe they're non-inferior. Okay? But the Constitution does not say how you remove these officers. What we can infer, though, is that it would be very, very dangerous to an executive to force him to deal with his predecessor's officers, right? It would be a violation, I think, of the separation of powers to force a president to deal with a principal officer, the Secretary of Defense, appointed by the guy before. It would get in the way of his duty to faithfully execute the laws. Okay, everyone with me so far? Everyone get that? All right. So the text of the Constitution is silent. But this issue proves to be fairly controversial. Now, let's see. Is that Jonathan? So, all right. So we did the text of the Constitution. Let's go on to the other substance after it. So remember there was a discussion of the Federalists in the Myers. Remember what Hamilton said about the removal power? Did Hamilton think in Myers that Congress could limit the removal power? What did Hamilton say? Anyone got it? Hamilton. It was Federalist something, I think. Anyone?
Is he like kind of worried on what the president's power can extend to?
Yes. Did Hamilton think that the president had the power of removal alone?
No.
No. The answer is no. So we're talking about Hamilton and the Federalists, right? These were documents written within months after the Constitutional Convention. And Alexander Hamilton said, the Constitution does not give the president power of removal. How does it work according to Hamilton?
Why is it, he said he needed senator consent necessary to remove, but then he later recanted his view.
We'll go to the recanting later, but you're right. Hamilton and the Federalists wrote, you have the Senate to appoint people, and you need the Senate to remove people. Hamilton said on both sides of the equation, you need the Senate, right? I'll go back to you, Jonathan. Why do you think Hamilton required the Senate to be involved on both sides, both appointing and removing? What do you think the reasoning would be there?
I mean, I guess the easy answer is Hamilton had a fear that things, president would gain too much power, like they just dealt with the King of England, and that he wanted all decisions like that to be able to be in check.
Yes. Just think about it, right? If the Senate approves of a person for a job, right, they approve of a man that the president appoints. That means the Senate's already giving their blessing to that person. Hamilton said, why should the president be able to unilaterally, by himself, get rid of the person they already approved? Right? So that was Hamilton the Federalist. Okay. Next, we turn to a case which we already studied, Plowman, which is Marbury versus Madison. All right, so we have Alexander Hamilton saying that you need the Senate to remove. And then we have Marbury. This is discussed in the Myers case, Plowman. What did Chief Justice Marshall say in Marbury about the removal power?
About the removal power?
Yes. Marbury is discussed.
In terms of the president's removal power?
Yes. It's in there. Lauren?
It's more in Brandeis dissent. Is that what we're looking for?
No, I'm talking about Marbury. It's discussed in Myers.
Oh, yeah, no, in Myers, in the one of the dissents or in the,
Yes, well, yes, it's discussing Marbury. So what's said about Marbury? Who was the officer? Who was William Marbury? What was his position?
he was an inferior position.
Well, what was his title?
I can't remember.
He was a justice of the peace, okay? Let's go back to the first week of class. William Marbury was a justice of the peace, right? In this case wasn't a removal case, right? It was actually an appointment case, right? The question was, at what point was William Marbury appointed as justice of the peace? Did he actually to get his commission, his piece of paper? Court said no. He got it once it was signed and sealed. The delivery was not necessary. But how did Chief Justice Marshall characterize Marbury's position? Could Marbury be eliminated by Jefferson at any point? No. Lauren, why not?
Because that, he was saying, I think he was saying that that power is not.
He used one word. What was the word Marshall used?
It's not absolute.
No? Was it? Irrevocable. Marshall said in Marbury versus Madison, Marshall wrote in Marbury versus Madison that the position was irrevocable. That for this justice of the peace position could not be revoked. Everyone understand that? So you have Hamilton saying the president cannot remove officers without the Senate's permission. You have Marshall saying that these positions are irrevocable, that the president cannot remove them. Everyone see this? Did your hand up?
Yeah, so with Marshall, I saw it more as like a contract issue where you made a commitment to someone, you're not going back on your word. Whereas with Hamilton, I saw it as more of like an issue of taking power away from Congress. Is that fair?
Okay, so now we have this evidence, right? Marshall says it's irrevocable. Job, did Marshall say anything about the Senate?
I don't believe so.
No, he didn't. The later courts, and this is why it wasn't the Brandeis dissent, basically say that Marshall didn't know what he was talking about. They say, what did Chief Justice Taft say in Myers? It was a dicta, right? It was a dicta. It wasn't necessary to the holding of the court's opinion. This wasn't a case about appointment. not a case about removal. So the Meyer court and Chief Justice Taft said, we're not going to follow Marshall because it doesn't count.
That's what I was thinking. I thought the case we were talking about was they caught him that he couldn't just go straight to the Supreme Court. That was the whole purpose of that case.
Are we reading Marbury narrowly now? See, this is an interesting issue in Supreme Court lore, right? When you have a Supreme Court opinion that says something, do you follow it or not? Well, generally, when the Supreme Court says something, it means a lot. There's lots of dicta in Marbury's opinion. Technically, the entirety of Marbury v. Madison is dicta because there's no jurisdiction. If there's no jurisdiction, the entire opinion is irrelevant. But precisely, your point's right. The case had nothing to do with removal. No one was trying to fire William Marbury. The case was about whether he actually had his commission. And Jefferson put in this one sentence that wasn't necessary to the court's decision. Was it a holding? Was it a dicta? What's a dicta? Michael, what's... So the short answer is that's right. Dicta is something that's not necessary to the court's holding. But a better answer I like is dicta is something the court doesn't want to follow. When a court labels some precedent as dicta, they don't have to follow it. It's no stare decisis. So be very attuned when you read cases. When a court says, oh, no, that was just some dicta. We'll see this a lot when we get to Morrison v. Olson, where basically the Supreme Court ignored 75 years of precedent. Like, oh, that's not what they really meant. That's not what they meant. Here's what they really meant. Okay? So we have Hamilton. We have Marbury. Okay? Sarah's good. All right. So, Demi, what happened in 1789 in the very first Congress involving none other than James Madison about removal power? Okay? So let's be very precise.
They went over whether to allow the Senate to approve or whether the Senate would be involved in the process.
Okay, that's kind of right, but let's be very, very precise, Debbie. You're on the right track. Did the Senate actually consider and debate whether the Senate could remove? I'm sorry, let's do it again. Did Congress actually debate whether the president needed Congress' permission to remove? Was that the actual question? What was the exact issue? Let's be very precise here.
Well, it said it was that Mr. Benson was objecting to the clause removal by the president.
Okay, that's right. Okay, so let me ask you a follow-up question. You're on the right track. Okay, Demi, let me ask this question. Let's assume for the moment, let's just pretend that the Senate has the power to control removal by the president, right? Let's say the president can't by himself remove people. Can the Senate decide not to exercise that power? Could the Senate say, you know what, Mr. President, we're creating a position and we're giving you the power to remove by yourself? Can Congress do that?
Yes.
Yeah, right? If Congress wanted to, they can say, you know what? We're creating this position of the Secretary of the Trees, whatever you want, Secretary of the Forest. I don't know. Secretary of the Forest, what existed back in 17? I go trees. Okay, you'll be the Secretary of the Forest, and you know what, Mr. President? We are giving you the power to remove this secretary by yourself. Any problems there, Demi? Okay. But is that Chloe? Okay. So there's no problem if the Senate wants to give that. But what happens if in the statute they say, we are creating the Secretary of the Forest position and it's removable by the president alone, right? What might some people think about the fact they said it's removable by the president? What might someone think about that? What would happen if that language was perhaps omitted somewhere else?
Omitted somewhere else?
Yeah, say in a future law, they didn't include that language, removable by the president.
Well, then that would imply that it's basic removal process is the president with the confirmation of the Senate.
Good. So follow me. This is a little bit tricky. Okay? If Congress writes in the statute that this Secretary of the Forest is removable by the president, in the future, people may think if that language is omitted, if that language isn't present, that the Senate must consent to removal. By writing that phrase, removable by the president, they were worried that in the future, if that language is omitted, people may think the president can't remove him alone. Everyone understand that? If you understand that, raise your hand, please. Yeah, okay. I'll say one more time. This is the opinion doesn't do a very good job explaining this part, which is unfortunate. If I write in a statute that the president can remove the Secretary of the Forest, and then I create a new statute saying the Secretary of the Lakes, right? I say nothing about the removal power there. That would lead people to think that because that language was not included, the Secretary of the Lakes cannot be removed. Okay? So what Madison's discussing here, what Madison says, is we don't want future Congresses to be confused, right? We don't want to set a precedent where we need to put in that language. In other words, to say it simply, the presumption is a president can remove someone alone, right? The baseline presumption is a president can remove someone alone. Everyone see this? Okay. Everyone get with me so far? Okay, so Ian? So we said that the baseline presumption is the president can remove someone alone. Does this debate with James Madison say that the president has the ultimate power, no matter what, to remove people from office? Does the debate actually say that? What's all that it says? What's the only thing this debate says?
It just implies that massive power is not.
Yes. Okay, and that's exactly right. This entire debate with Madison and Benson does not say the president has the power to remove alone. It does not say that the Senate can't keep some control on this. So there's nothing in this Madisonian debate from the first Congress which says Congress has no power of removal. In fact, I think it can be read to suggest Congress retains some power over removal. If Congress wants to give the president a blank check, they can do that. They can give him full removal power. But if Congress wants to keep some strings on the removal power, it seems they can do that also.
Don't they have removal power implied in the fact that they can be the president's next guy that he recommends?
Yes,
So
but that's not
is that
removal.
the same thing?
Well, is voting down the next guy removing him?
Kind of more time than the last guy.
What if the last guy refuses to resign, doesn't die? What if the previous guy doesn't resign, refuses, which is what happened with Meyer and Humphrey?
I mean, that'd be
How?
the president will just.
But that's the issue. Can the president remove? Right? The issue is, can the president remove in the absence of the Senate's permission? Well, the answer isn't entirely clear. Right? So what I want you to convey is in this early history, right? We have the Constitution's text, we have Hamilton the Federalist, we have John Marshall and Marbury versus Madison, and we have James Madison in the congressional debates, right? Hamilton, Madison, Marshall, right? And the Constitution itself. So we have the closest we get to what the founders thought more or less suggests that the Senate can retain some role in the removal of officers. Okay. Congress need not exercise this power, right? Congress can say to the president, you have full permission, but they can. They so choose. Okay, so for the first then about 75 years of our republic, Congress didn't really do anything about this. They gave the president effectively full power of removal. What changed, Connor? What significant event in American history altered this relation between Congress and the president?
I guess it would have been after the Articles of Confederation.
No. In recent years, right? Not recent, but after the Constitution was ratified, what significant event changed the relationship between Congress and the president with respect to appointments? This was discussed in the Myers case at length.
The tenure of office.
Exactly. Andrew Johnson and the Tenure of Office Act. So a little bit of background for those of you who might not be familiar with the history. After the Civil War, the Congress, which was controlled almost predominantly by the Republicans, implemented what was called Reconstruction. Okay, what was Reconstruction? Rebuilding the South from the ground up. They effectively put in a number of programs to vanquish former Confederate forces, provide protection for the freedmen, the freed slaves, and bring the South back into the Union. President Andrew Johnson, who became president upon the assassination of Lincoln, was a Southerner who was somewhat sympathetic to the South and did not like Reconstruction. He didn't like it, and he attempted to thwart it. He attempted to remove people who were Lincoln's friends. He tried to get rid of Edwin Stanton, the Secretary of War. This was Lincoln's Secretary of War. He tried to block all these different Reconstruction policies. He went up against the Congress, and he almost lost. So after he tried to fire the Secretary of War, Congress enacted the Tenure of Office Act. Connor, you mentioned it. What is this Tenure of Office Act?
Basically, the president retains the authority to remove officers that are appointed ratified by the Senate.
He has the power? Yes. The Tenure of Office Act says the president cannot remove anyone without the consent of the Senate. Anyone. If the president wants to fire the Secretary of War, he needs the Senate's approval. Jacob, why was it such a significant provision during Reconstruction? Why was it so important? For what purpose? Exactly. This law was passed as Tenure of Office Act to stop the president from blocking Reconstruction, from bringing the South back into the United States of America. Johnson vetoed the Tenure of Office Act, arguing that it was unconstitutional. The Congress, which was almost entirely Republican, because at this point, most of the southern states didn't have representation yet. Southern states were all Democrat at the time. Overrode his veto. Not only did they override his veto, the House voted to impeach him. Why did the House vote to impeach him? Because he vetoed the Tenure of Office Act. This is where separation of powers gets real. Okay, this is not a joke. Congress tried to assert a power that they believed they had over his removal. They thought they had this power. The president said, no, you don't. I'm going to veto it. Congress not only overrode the veto, they voted to impeach him. He came one vote shy in the Senate of removal. One vote. One vote. This is such a big deal. One more vote, the president would have been removed. It's never happened before. And a number of people have voted to acquit him Did it because they believed the Tenure of Office Act to be unconstitutional. So this constitutional issue over removal, which you might think is stupid about a postmaster in Ohio or whatever, right? This almost resulted in probably a second civil war. Both. It was basically a disrespect to the president, a disrespect to Congress, because they removed him. They thought that was unconstitutional. Then he tried passing an act to limit the president. The president vetoed that, and they overrode his veto. It's an odd thing when the president vetoes a bill that limits his own power. It's a very odd thing indeed. Can you imagine during Youngstown, right? We did Youngstown first week of class. Congress passed a bill saying, you know what? We want to pass the Anti-Steel Seizure Act of 1952, right? Congress passed a bill saying the president cannot seize the steel mills. Imagine if Truman vetoed that, right? Imagine what Justice Jackson would say if President Truman vetoed a bill that was meant to limit his own powers. That would have been a big deal. Fortunately, Truman didn't do that. He just drank some whiskey with Justice Black, or bourbon. All right. So the issue then, until 1867, Congress had never really put strings on the removal power. The Tenure of Office Act was implemented. Now, a number of presidents continued to believe that this act was unconstitutional. They said this law cannot stand. And eventually, the Tenure of Office Act was repealed. But before it was repealed, a statute was passed concerning the appointment of postmasters. Right? What did the law about postmasters say? Is that Christian? What was the law discussing postmasters? Uh-huh. Louder? I can't hear you. And how were they to be removed? Okay, exactly right. While the Tenure of Office Act was in effect, Congress passed a statute that says, listen, if you want to appoint a postmaster, you need a permission. And if you want to remove him, you also need a permission. This law was signed by the president. Karishma, if the president thought this law was unconstitutional, why did he sign it? Why would the president sign a law that he believes to be unconstitutional? No, but this law took the power away from him. This law said he doesn't have that power. Why would the president sign a law that he thinks is unconstitutional? Why wouldn't he veto it? Think about it. Did this law, this law had a lot of different provisions, right? Do you think the president would veto a law where maybe he likes 5 things and dislikes 1? What do you think? Maurice, what do you think? I'm sorry, go ahead. Why not? Maurice, what do you think? I'm sorry? Good for him. Okay, Maurice, what do you think? Louder, I can't hear. I'm sorry. Well, if he vetoed it, would it go through? Well, those are very hard to get. But the more important question, Maurice, is why would the president veto this big bill where he likes 10 things and dislikes 1? What do you think the issue is there is? Power? What do you think? Is that Lauren? Come on. Well, Lauren, let me ask you this question. So say the president says, you know what? This is what President Cleveland did, right? He says, you know what? I'm signing this bill, but I think this provision is unconstitutional. What do you think would ever happen if the Senate required him to get consent, do you think he would listen? No. What happened in this case, the very case we have here? Did the president obtain consent before firing the postmaster? Even though the statute said you need to get consent, right? So here's the issue, right? The president signs the bill. He says this provision is unconstitutional. Will the president comply with an unconstitutional law? The president says, I have an independent duty to execute the Constitution and the laws. I'm going to sign this, but I'm not bound by it. Oh, and this is where stuff gets interesting, right? This is where it gets funny. The president signs a bill that he knows to be unconstitutional, and he says, I'm not going to follow it because I have a duty to execute the Constitution. Does that trouble anyone? So there's something called a signing statement, which you may have read about, right? These have been issued by presidents for many, many years. The president signs a bill saying, you know what? I'm signing this postmaster law into effect because I like other stuff. Like I really want to create a post office in like Oregon. I think it'll be a great thing for all the hipsters to like, mail kale, whatever, whatever goes on in Oregon, right? But I don't think this removal provision is legal. So I'm not following it. And that's exactly what happened in this case. It was signed into law. I think it was President Wilson said, you know what, this guy Myers is a kind of a jerk. I'm going to write to him, ask him, dude, resign. He's like, no, I'm not going to resign. He's like, okay, you are fired. Remember Donald Trump, right? You're gone. You're fired. So that's how this case arose. Yes?
So if he signs something unconstitutional, he wouldn't be bound to it?
Exactly. He signed something that he thinks is unconstitutional, so he thinks he's not bound by it.
I would argue that if the president signs something that he believes is unconstitutional, then would that be a violation of his duty to execute the law to begin with?
Is signing law executing it?
I would argue that it is because, that's the first step of executing it.
Now, I'm going to ask you a very specific question. Is a law unconstitutional or enforcing it unconstitutional? Right? This is a very technical question. If Congress passes an unconstitutional law on the books that's not applied to anyone, is there any problem with it? Plowman. Congress has lots of laws in the books that are unconstitutional. If they're not applied to it, if no one's subjected to those laws, is there a problem?
Yes, not.
If a tree falls in the forest and there's no one there to hear it, does it make a sound? I'm not speaking rhetorically. It's actually a very good question, right? I'll give you a good example. Lawrence v. Texas, right? We'll do this case in a couple of months. This was a sodomy case from right here in Harris County, Houston. Texas had a law in the books that said sodomy is illegal. It was never enforced. And only by some really funky circumstances, I'll tell you later. The case is really weird, right? But the facts are very odd. I'll tell you that later. But finally, police arrested someone charged Mr. Lawrence with sodomy. In Virginia, where I went to law school, right? The sodomy law is still in the books. It's still there. Never been repealed. But because no one's been prosecuted under it, there's not been a single court challenge to invalidate it. It's still in the books. If you go to the library, you can find it. Take you 5 minutes. The mere fact that something's in a law book doesn't mean it's unconstitutional. Only when it impacts you. Only when you're injured by it. This is the idea of standing, right? We discussed this briefly. But you can only challenge a law in federal court if it injures you. The mere fact you have a book. So, you're asking a very good question. I'll get to you in a second. But the mere fact you have an unconstitutional law in the books doesn't necessarily mean he's violating his oath. There's arguments he is, but it's a close question. Sarah?
I may be way off, and you told me that my friend told me that case was because he wanted to challenge that law, so he kept trying to
Short answer is yes. So the short answer is yes. So the lawyers who got onto his case were looking for a sodomy case to challenge for a number of years. there were almost no sodomy prosecutions in the United States. In fact, they intentionally, and this is somewhat rumored, I'm not sure if it's true, they intentionally asked for the judge to issue a higher fine. That way it would be appealable, because certain low fines in Texas aren't even appealable. So this was a case they wanted to go to the Supreme Court. So yes, the short answer is yes, they wanted this case to go up because they were looking for a sodomy case to prosecute somewhere, and there weren't any. It's an odd thing about legal challenges. You need someone who's actually arrested to go to court. Pre-enforcement challenges. You can't say, well, you can say, well, maybe they might arrest me one day for this thing. You know, maybe I engage in, I'm not gonna say that, but, you know, camera's on, right? But in theory, a person can say, I engage in certain activity, right? Maybe I'll get arrested. That's not good enough. You actually have to be arrested. This is why a lot of civil disobedience, where people break the law in front of police, saying, all right, arrest me because I want to be arrested for this. Yes, sir.
Just to go a little bit further past even the tree making sound, you also argue that it's not technically a law until he signs it, so therefore the act of signing it isn't violating his duty in any way. I mean, before he signs it, it's not a law. So if it's not a law, then it's not.
Yeah, I mean, that's an argument. It's a really tricky question. And then I go back and forth with myself. Why would the president sign a law I think is unconstitutional? Now, who wrote the majority opinion in Myers, right? Is that Jonathan? Jonathan, who wrote the majority opinion in Myers? Who's Taft? Who's Taft? He was the president. He was. William Howard Taft was the only person to serve as both the president of the United States and the Chief Justice of the United States. I'll show you his picture in a minute. Dude had an awesome mustache. He was also huge. What?
He actually had a brand new bathtub put into the White House.
Yes. So there's a rumor that I think is probably true, where he once rode a horse and broke the horse's ankles. In fact, the Society for Protection of Animals sent him, they said, let's send you an elephant to ride on, or a camel. In fact, I actually clerked in the Sixth Circuit where he was formerly a judge, and his chair is like, you know, this big. It's like a equator around him. But the guy was huge. But we cannot forget, he was president and then Chief Justice, right? Jonathan, how do you think that impacted his views on executive power? What do you think when you have the former president sitting as the Chief Justice?
Probably thinks they deserve more power than Congress gave them.
Yeah, and this is discussed in your book. He actually exercised removal power in a couple different ways. To give you the background, Teddy Roosevelt was a very big conservationist. He loved trees, right? That's where I was going. He loved trees. So Secretary of the Forestry was a guy named Pynchon, who stuck around after Teddy Roosevelt left office. Taft fired him. Roosevelt was really, really mad at him. But Taft said, you know what? I don't like him. He's Roosevelt's man. I don't want him anymore. I'm going to fire him. Right? So we have this history, right, leading to the Tenure of Office Act. All right, so let's actually go to the facts then of of the case. Gabriel? So what was actually at issue in Meyer v. United States? What were the facts there? We discussed it roundabout. What were the facts? Uh-huh. Uh-huh. Exactly. He didn't resign. He did not. Oh, yes. So the president demanded that he resign, right? Right. Okay. And once he's removed, did he continue collecting a paycheck? Did he continue getting paid for his job after he's removed from office? No. Okay. So, let's see. Is that George? George, let me ask you this question. So the Tenure of Office Act was in the books for, 50 years, whatever, right? Did anyone ever challenge it as unconstitutional, to your knowledge? No, after the Tenure of Office Act was overruled, the veto was overruled. Did anyone ever challenge its unconstitutionality in court? Why do you think no one ever challenges constitutionality in court? No. Who here was able to challenge this law? Who is the plaintiff? What's his name? Myers. Why was Myers able to challenge this in court? Not the removal. What got him into federal court? What court was he bringing this claim in? Be very precise. No, he wasn't the Supreme Court. Do you have it, James? The Court of Claims. What was he suing over? His paycheck. This was his injury. His injury was he didn't get paid. He wasn't claiming in the abstract that the Office of Tenure Act was unconstitutional. He couldn't because that's not an injury. I can't go to federal court and point to a law book and say, see that statute right there, Judge? That statute's unconstitutional. The judge will say to me, what the hell are you doing here? Okay? But Myers said, listen, by the president, I was confirmed. I'm entitled to a paycheck for 4 years. I didn't get my full paycheck. Therefore, I have a constitutional injury. The only reason why this case got to court was because he didn't get paid his salary. Everyone see that? The exact same facts are in the Humphrey, which we'll do in a couple minutes, right? Humphrey didn't get paid. So he went to court to sue. Now, this is a kind of a funny side note. Pedro, what does it mean Humphrey's executor? What's an executor? What happened to Humphrey? What happened to Meyer? Yeah, what's up with that? I've actually looked into this. I tried finding their obituaries. I couldn't find anything. I have a friend who thinks something was up that, like, someone off them, but I have no idea. So basically, they both died. So their estates, right? Their executor, I think it's widow, whatever, was continuing the lawsuit in his name in court. Because even though he was dead, if you've taken wills and trusts, which you will soon, you still have money coming to the estate, right? You can have royalties, whatever, paid after your life. So the estate of Meyer and the estate of Humphrey brought this lawsuit. All right. So Gabriel, what does Chief Justice Taft hold? Can the president remove this post office master on his own without the permission of the Senate?
No.
Okay. I'm sorry, I think it's double negatives. Is the statute constitutional? Is the statute limiting the president's removal power constitutional? Yes.
Yes.
Well, no. What's the holding of the case?
It says in that by which unrestricted power removal the first constitutional
In your own words, sorry.
is in violation of the
What's in violation of the Constitution?
removal of
The what?
the removal of the
No. Yasmin?
It's not the president's unrestricted removal.
Can the Senate, I think you're saying the right thing, but the wrong way. Yasmin, can the Senate require consent before removal? No. Yeah. What's the holding of the case?
Is it that the statute itself is unconstitutional?
Yes. The statute is unconstitutional. The statute says to remove a postman, you need to have consent to the Senate. The Supreme Court, by Chief Justice Taft, says that statute is unconstitutional. Right, Elliot? Why is it unconstitutional?
Because it restricts the unrestrictable power.
Yes. Taft says very clearly, this is an absolute power of the executive. The executive can remove whomever he damn well pleases. All right? Now, Taft has some lifting to do. He has some heavy lifting to do. Because we have Hamilton, we have Marbury, and we have Madison. We have Marbury and Madison, as it were. Right? How, Amanda? How, Amanda, does Chief Justice Taft deal with Marbury? What does he say? Marbury said that this power was irrevocable. How does the Chief Justice deal with Marbury? The number one case of all time that we all study and every law student knows by heart.
I think, doesn't he just kind of say that it's dicta?
Yes.
Not-
Yes. So Taft says Marbury versus Madison is dicta. Right? That this was a case about appointment, not about removal. It doesn't apply. Okay. Now, Alana, how does he read the great decision, the 1789 decision with Madison? How does Chief Justice Taft understand that? Well, what did the Madison 1789 decision say? What did Madison actually do?
To give the Congress.
Renee?
That the president alone.
Well, what was the actual issue with the first Congress? What did they actually do? Discussed this a few minutes ago. Jennifer?
You mean like you have to have the advice of the Senate?
Did the decision of the Madison, the first Congress, right? Did they seem to think that you needed the consent of the Senate? Oh, no, don't do that. Which one is Megan?
I think no. The power, was about the Supreme Court.
No. Mary? What was the great decision? What was this decision with Madison in the very first Congress and Benson? Had they reached that conclusion? What did they do to reach that conclusion?
Because I said, didn't I say that he would have more, that he would better know whether or not he'd be suited for the office?
That's a good policy argument. What did they actually do? Job?
Was it drawing the distinction between inferior and superior officers?
No. Renee, want to try that again?
Say voted?
Yes. What was the vote? How did they vote? What was the nature of this vote? What did he move to strike? What was the significance of removing that clause? Yes, exactly. The very first Congress, they were trying to make the point, or so Taft says, that the Senate does not need to be involved in removal. The reason why they removed that language was to make clear the president had the power alone. Okay? That's what Taft says. I don't know that that's entirely right. That may not even be correct. But Taft says that Madison, the first Congress, wanted to give this power to the president alone.
That's not what you said earlier.
I'm saying what Taft said.
Okay, but that's not what you said.
I don't agree with Taft. Taft says that this is evidence. Taft said this is evidence that the first Congress wanted the president to have this power alone. Now, Connie, why do I think Taft is wrong? What did I say earlier? You're right.
I thought you said, they were saying one thing or the other, but they were alluding that Congress and the president both had it because they wanted that balance.
I think that's the better reading, right? And Brandeis makes his point in his dissent. By the way, when a justice says something, it doesn't mean it's correct. I know that's a very difficult thought for you, but you are intelligent people. You can have your own power of reason, and you can assess the evidence, and you can make your own conclusions. Taft's decision, while well-researched, I think draws a few conclusions that maybe aren't exactly right. But Taft seems to think that this great decision makes clear the Senate is not involved at all in the removal. So Taft walks through this history and says, listen, until the Tenure of Office Act, there was no efforts to limit removal power, right? Hector, what inference should we draw from the fact that for 75 years, Congress never tried to limit the removal power? What should we think about that?
I think that generally it was accepted that the president should retain this power.
Right. And when did it change? When did this policy change to restrict removal power? What events occurred? Civil War. This is a very dangerous time when Congress and the president were at war with each other. And Taft is like, listen, guys, we can't use this one instance as the rule. This was the exception to the rule. The general rule is for the entire republic was that Congress placed no restrictions on removal. That is the rule. That's a Taft. So Taft makes very clear, and this is the holding, loud and clear, the president alone has the power to remove these executive officials. There's no question. None. Zero. Zilch. Okay. So I'll go on to Vicky. Vicky, after you read the first case, after you read Myers, if I were to ask you, are there any limits on the removal power, what would your answer have been, just after reading the first case?
Yes.
What removal? What power? What limits are there?
The limits for the presidential
Are
power?
there any limits on the president's removal power?
Well, he's limited to the approval of Congress for inferior officers.
I only said after the first case.
Oh, okay, then no.
That's right. No, you're right. If you after case 2 and 3, there's other stuff, right? But the clear holding of the very first case, Myers, 1926, whatever. The president alone can remove people. The Senate has no power to control that. The Senate cannot pass any laws controlling removal. Period. Full stop. Any questions on the first case, Myers? Okay. That brings us to our second case. I'm sorry, let's do I'll do the dissents briefly before I go on to Humphreys. Justice Brandeis's dissent makes the point that postmasters are inferior officers. Right? He says, listen, we're not talking here about the Secretary of War, right? We're talking about the Secretary of a postmaster. So let's go back to the text of the Constitution. Aleda? The last clause, right? We read this right. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president or the heads of the department, right? When Congress creates an office, can they design how to remove it?
I would say so.
Why?
Because they created it.
So if they create an office that says the heads of the department can appoint people without Senate's permission, can they say, but we need Senate permission to remove them? Would that be permissible? In other words, Congress says here, listen, you don't need our advice and consent to appoint anyone, right? The head of the department can hire Jason whenever he wants. But if you want to fire them, you need our permission. Could Congress do that? Why would Congress want to do that?
To have superior power over the decisions of the heads of the
Oh, I'm thinking of a more political thing. Michelle, why would the Senate want to have a say whenever some civil servant's removed?
Is it so they can check the president?
What's a more bureaucratic reason?
Are you in charge of the pay and
Yeah, yeah, try.
what if they don't, what if these appointments don't agree with the making sure that
These are low-level people. They deliver the mail, right? They're not making any policy decisions. What do you think?
I was gonna say, so that they can prevent him from voting like his opposition.
These are postmasters. They're not high-ranking officials, right? Anyone? Job protection. The spoil system. Civil service protection. I am not exaggerating here. Today we have unions and things of these natures which make it effectively impossible to fire a federal employee. But that didn't exist back then. So what the Senate says is, we'll build in job protection. We'll say that you can't fire this person unless there's really good cause. Right? You don't need the Senate's permission to fire him, but you need really good cause, right? So for inferior officers, if Congress creates these positions, they can limit their destruction. And the Constitution specifically distinguishes between inferior and principal. Right? So Brandeis's position said, listen, these are little, middling, low-ranking positions. Congress creates them. They can be destroyed by Congress as they see fit. Okay? All right, very good. All right, any questions on Myers? We move on? All right. Is that Maria? Maria, what were the facts of Humphrey's executor? Who's he?
it is Humphrey.
Okay, who is Humphrey?
He was a commissioner of the Federal Trade Commission.
Good. Hold on one second. By the way, in case you want to see the mustache contest, we're past November, but here is Chief Justice Taft's mustache. I think Justice Holmes hasn't beat.
Yeah.
I don't think it's even close. And this is Justice Brandeis, if you will. Okay. So we have here Humphrey. Okay. William Humphrey was a commissioner of the FTC. So I need to give you a little bit of background information for this to make sense. Most federal agencies you think of, the Department of Defense, the Department of State, Department of Treasury, these are all agencies which are headed by individuals who are directly accountable to the president, right? The Secretary of Defense answers to the president. The Secretary of State answers to the president, right? These are directly answerable to the president because they enforce his policy. But in the early 20th century, Congress created what are called independent agencies. Does anyone know what an independent agency is? Anyone? Yeah? Oh, you're next too, perfect.
It's an agency that the president has the power to appoint or create these agencies if they're separate from Congress. And you still have to follow.
You're in the general ballpark, okay? So the idea of an independent agency was saying we need to insulate the administrative process from the political branch. So rather than having one officer at the head of something like the Federal Trade Commission, which makes trade policy, we'll have 5 people. We'll have a board. 3 people from the president's party and 2 people from the other political party. So say if the president was a Democrat, you'd have 3 Democrats on the board, and then you have 2 Republicans on the board. And the idea is they would work together and vote on stuff and make policy decisions. So that way, instead of having 1 person, you have 5. But the important part here is that these officers of these agencies do not work for the president. They're supposed to be independent, although they usually not very. Why are they independent, right? Why would it be important to have, Whitney, an independent agency? Why is this significant?
It would be significant because it kind of limits a one-sided political.
Well, let me ask you this question, right? If we have certain things that are important, the Federal Trade Commission, the Federal Communications Commission, or the Security Exchange Commission, right? These are very important matters. What if Congress decides they don't want the president saying this policy alone? What's the benefit of having people from both parties on this board?
Because you're going to have more of the potential opinion of everybody.
Yeah, you build a consensus, right? When you have the Secretary of Defense, he's one. He answers to the president. War policy is made by one person. But when you have something about fair trade or fair communications, You want different people, okay? But the administrative agencies turn the Constitution on their head in a really weird way. We said from the very first class, you have the legislative, you have the executive, you have the judicial, and they're all separate. The independent agencies blur these lines very, very badly. They actually exercise all three powers in one. It's just like three-headed chimera, right? Kerberos, if you will, if you like mythology. They make rules. Independent agencies make rules. Call them regulations. But these regulations have the force of law. So in this sense, they're quasi-legislative. They can't pass statutes, but they can enact regulations which have the force of law. So first, they have a lawmaking power. Second, they have an executive power. They can prosecute you for doing stuff. If you dump something in your backyard, the Environmental Protection Agency can go prosecute you and fine you. They can throw you in jail if they charge you with a crime. So they have an executive power, a quasi-executive power. They also exercise a judicial power. If they issue a judgment against you that you don't like, you can actually appeal it to them. And they actually have people who pretend to be judges and may even wear robes who issue a decision against you. They're not judges. They may call themselves administrative law judges. They are not judges. They are not judges. They can call themselves whatever they want. Give them a gavel, but they're not judges. So you have these administrative agencies that exercise all powers of government. They make regulations, they enforce them, and they have judicial proceedings. What the heck are they, Cindy? What are these independent agencies? Where do we fit them into the Constitution? Where do they fit in? Neither am I. So if you recall, in one of the opinions we read earlier, that this was often called the fourth branch of government. And I think that's a fair characterization, right? These administrative agencies are something of a fourth branch of government. They're neither fish nor fowl. They don't really fit in as executive branch agencies. They're not really legislative agencies because they're not Congress, but they exercise judicial powers. What makes them even more interesting is how these 5 members of the board are appointed. Right, Jason, so what's the process of appointing someone to these boards?
The president appoints, let's see, president.
And then we'll use the Federal Trade Commission as an example. And Mr. Humphrey over here, who has no obituary that I could find, but I will avoid any speculation. Jason, how is Humphrey appointed?
By the president.
And then what did the Senate concur?
Senate confirmed.
Okay, so how long was Humphrey's term? He's not appointed for life. How long is his term?
4 years.
Okay, so Humphrey's appointed by the president for four years. Okay, everyone with me so far? He has a 4-year term.
7 years.
7, whatever, right? He has a 7-year term. Actually, the year doesn't matter nearly much. 7-year term. Change of the presidency. Who comes into office? FDR. Roosevelt. The predecessor was Herbert Hoover, Republican. The next guy is Roosevelt, Democrat. Does Alejandro, does President Roosevelt care much for Mr. Humphrey?
Probably not.
Why not?
Different political views.
Okay, but didn't I just say a minute ago that the purpose of these boards is to have people of each party? You have 3 of one party, 2 of the other. Wasn't that the purpose of these?
Sure.
So what could Roosevelt have done to get rid of Mr. Humphrey constitutionally? How could he have gotten rid of him? Other than killing him. What? No, I didn't say that. How could he have just gotten rid of him?
Just revoke his.
No. What would the easiest way have just getting rid of him?
I mean,
Anyone? No, I'm thinking much simpler than this.
Get congressional approval?
He could have gone congressional approval. What else could he have done?
Ask him to resign.
Well, that he asked, that didn't work.
Claim that he wasn't doing his job properly.
Okay, so he could have claimed. I'm thinking of a really easy one. He could have waited.
Elective duty?
Yeah, he was on.
He had a couple months left. So you see the problem here, right? He had like 8 months left. Okay? He didn't have that much time left. So he could have just waited the guy out and replaced him. But Roosevelt wanted this as a test case, right? He wanted to test whether he could remove people from independent agencies. So yes, you're all right. He could have claimed he was acting poorly. He was, he wasn't engaging. He was not doing his duties, but that wasn't true. Humphrey was doing his job until he mysteriously died, right? So he asked for his resignation, said, well, hey, Humphrey, good buddy, old pal. Remember that election we just had where all those people voted for me? Yeah. They like me. They don't like you. So let's just end things amicably. And Humphrey says, no. And then Roosevelt's like, well, you really should resign or else. And the guy's like, you're going to have to fire me. Okay. So Roosevelt sends him a letter saying, effective immediately, you are terminated from this position. You're fired. Right? Everyone see that? Humphrey does not agree. He says, you can't fire me without the permission of the Senate. Right? You cannot remove me because I'm an independent. I'm at an independent agency. So once again, he files a
Well, they call the previous ruling, they call it dicta again, and the other way. So basically, they have to do it for cause.
Well, the statute here said you can only fire for cause. But why is this case different, Sean? Why is this case different from Myers? Why is it that Myers, a post office guy, can be removed absolutely, but the commissioner of this independent be removed for cause? Why is that possible?
I think it's because of where that agency draws its power from.
Okay.
It's not specifically an executive office. It's that hybrid sort of falls in between.
Okay, perfect. What is this hybrid? What do you mean this hybrid power? You said it's a hybrid. Explain that to me. Walk me through that.
Well, it's not. Okay, we have the War Department. It's created by Congress for the president to do a very specific job that he has to execute those laws.
Yes.
This is something that's regulatory in nature that falls in between. Like we went over earlier, they can arrest people, they can issue fines, they can make rules, but it's not truly executive and it's not truly legislative.
So what do we call it?
Quasi.
Quasi. Thank you. Say it again, Neffy, please. Quasi. What does quasi mean? Like quasi-motor. What's quasi? A little bit of this, a little bit of that. So the court says that this independent agency, this FTC, is quasi-legislative and quasi-judicial. So it's not purely executive branch, right? It's not a purely executive official. The Secretary of Defense would be a purely executive official. Apparently the postmaster is a purely executive official. Go figure, right? But the head of the FTC, is a quasi-legislative and quasi-judicial. So the actual holding of this case is very easy, right? If there's some sort of position that's quasi-legislative and quasi-official, the Senate can limit his removal, right? For these quasi-legislative and quasi-judicial decisions, the Senate can the Senate can limit the removal. If it's purely executive, then the president has absolute power to remove. So everyone see the holding. That holding is easy enough to figure out. The tougher question is, how do you reconcile this with Meyer? Andrew, how the heck do you square this way with Meyer? How does this fit with Meyer?
I think you could say that the president has immutable power in terms of only purely executive offices, whereas if it's quasi-legislative, quasi-judicial, that power is necessary to extend.
Why? Why would we not want the president to have unlimited power for these quasi-legislative and these quasi-judicial officers?
Separation of powers.
Why?
Why do we want separation?
Yeah, why would we not want the president interfering with these legislative or judicial powers?
Need ambition to counteract ambition.
That's good. But I think there's a preliminary question, if I can take a step back. Caleb, why do these executive branch agencies have judicial and legislative powers in the first place?
Because they create.
Who created these independent agencies? Congress. What powers did Congress give to these agencies?
You make laws.
They gave legislative, executive, and judicial powers. Caleb, how can Congress delegate to these agencies legislative, judicial, and executive powers?
Through law.
Oh, I'm sure they did laws, but where does Congress get that power from in the first place?
Constitution.
Does Congress have the power to delegate judicial powers to these agencies? Oh. Where is the only place Congress can give the judicial power? What's the only place in the Constitution that can exercise that?
Section 1, or Article 1.
Where are the federal courts? Who are the only people that can exercise the judicial power?
The justices.
The judges, right? What tenures do federal judges have? What if you have someone who doesn't have lifetime tenure? Can they exercise the judicial power? The Constitution makes clear the judicial power shall be vested in one Supreme Court, other courts as Congress shall from time to time ordain and establish. If you are a federal judge, you have lifetime tenure. Can the judicial power be vested in these judges who serve for 5 years? Jocelyn, can the judicial power be vested in these judges? Yes, they can create inferior courts, but what tenure do those judges hold? What does the Constitution say about tenure for judges? Lifetime. So you have these courts. They mentioned this court of claims, right? It's called a court. People on there claim to be judges, but they lack lifetime tenure. They serve for 15-year terms. How can you have the judicial power in these non-Article III courts? That question is long since sailed. But it's a question which at one point was very relevant. This is the non-delegation doctrine we've discussed. Can Congress delegate this judicial power to these executive branch agencies? Right? I'll ask a follow-up question. Stephanie, who has a legislative power? Which branch of government has a legislative power? Not a trick. Congress. Can Congress give that power away?
I don't think so. I mean, they can give away their power, but to a certain limit, I would think, like.
So what's happened, your ambiguousness is probably on the right track. What's happened is Congress has delegated their legislative powers to these administrative agencies to actually make regulations which have the force of law. So the preliminary question is, rather ambition checking ambition, Congress has ceded all this power to the agencies. And now we've heaped on top of this, right, the fact that the president can't remove these people don't really work for him. We have a mess where instead of having very clear delineation between the Congress, the executive, and the courts, It's all blurred together. And now the president can't even remove people in his own agencies because the Senate says you can't. All right? So there's a lot of messiness in the administrative state. And again, this is a ship that's long since sailed. Its constitutionality is well settled. But when you try to understand why this case is so problematic from FDR's perspective, you have these agencies who don't really work for him. You can't remove him, yet they are creating law and policy that binds to his administration. So you can sympathize with that, I think. All right. So, yes, sir.
So it was because of the nature of the agency, the reason why the president.
Yes, right. So the holding, right? The holding of Morrison, I'm sorry, the holding of Humphrey is that for these independent agencies that are quasi-executive, quasi-legislative, and quasi-judicial, Congress can control removal. Because you have a little bit of courts in them, you have a little bit of legislature in them, we can't give the president all this power. We need to keep our check on it. So the Senate can limit removal for just cause. Right? So everyone get that. So we have this kind of arc, if you will, right? So we start with Morrison. I'm sorry, we start with Myers. Myers says, president can remove whoever he wants. Then we go to Humphrey. Humphrey says, well, he can't remove people at independent agencies because they have quasi-executive, quasi-legislative, and quasi-judicial powers. We'll keep this separation of powers. Everyone with me so far? Everyone get those two cases? Okay. Third case throws both those cases into the garbage. And I don't say that lightly, but Justice Scalia's dissent in this case is one of my favorites of all time. When Nino dissents alone, you know you're going to get a good show. So this is the Justice Scalia bobblehead. If you don't know, there's a publication called The Green Bag. It's a magazine actually published at my alma mater, George Mason Law School. And they make these bobbleheads for all the justices. And I love the one for Justice Scalia. I have one upstairs. I have a bunch of them. You'll see them. Of a wolf. And one of the most famous lines in this Scalia dissent, which I love reading, is that often a sheep comes in wolf's clothing, right? What does that mean? Well, sometimes when there's something bad that comes to you, it's wrapped up in this really nice thing that you don't really, you're not bothered by it. But Scalia says, this wolf comes as a wolf. What does that mean? This case is bad, and it looks bad. So a little bit of background first. Richard Nixon was a crook, right? You know, we can start there, but it gets a little bit more interesting. So during the 1970s, there was allegations that President Nixon was somehow involved in break-ins to the Watergate Hotel, which is where the Democrat National Convention held some records, right? It was kind of stupid, but it happened. So an independent prosecutor, a special prosecutor, was appointed to investigate. The special prosecutor got a little bit close to home, and he started figuring out that the break-in at the Watergate was linked to the White House. So what did Nixon do? Nixon said to his attorney general, fire that prosecutor. What did the prosecutor do? He resigned. Rather than do something he thought was wrong, he resigned. That took some fortitude. Okay, so when the attorney general resigned, the next guy gets elevated, right? So Nixon goes, fire that prosecutor. What does the number two guy say? I quit. This became known as a Saturday Night Massacre. So basically, Nixon fired 2 attorney generals. Third person in the Justice Department, a guy named Robert Bork, who will later go on to be a judge and Supreme Court nominee. Nixon goes to Bork, fire him. Bork fires him. Bork effectively said, you know, whether he's talk about Bork later, but he said, I fired him because if I didn't, the entire Justice Department would have collapsed. Because Nixon would have kept going down the line firing everyone until he found someone willing to terminate the special prosecutor. So eventually, the special prosecutor was terminated. But evidence was uncovered from this investigation that led Nixon to resign. This was really his downfall. So as a result of this Saturday Night Massacre, Congress passed the Ethics in Government Act. And the Ethics in Government Act effectively allowed Congress to request an independent counsel. This is her. Her name was Alexa Morrison. And Congress can request an independent counsel to investigate wrongdoing in the executive branch. So, and the procedures by which it occurs are actually fairly complicated. But the Congress makes the request. The Attorney General then says, okay, yes, we need independent counsel if there's some suspicion. And then the Chief Justice of the United States appoints a 3-judge panel who selects the independent counsel. It's really complicated and messy. But in any event, this was Alexa Morrison, and she was investigating this guy, Ted Olson, who was a person in the Reagan White House, for doing some bad stuff, withholding documents, right? Olson sued Morrison, hence the name of the case. And Olson claimed that the independent counsel statute is unconstitutional. Why is it unconstitutional? Because the president cannot remove this independent counsel. The key issue here is the president could not remove the independent counsel. Only if there was some sort of cause, only if the person engaged in some sort of bad conduct. But the power to remove was not absolute. Okay? So let's walk through this once at a time. Juan? So Juan, under Myers, the first case we did today, Justice Taft's opinion, don't worry about Humphrey. How would this case come out under Myers? Easy, right? This is an easy case. Under Myers, Taft says, listen, the executive has to decide his own cabinet, right? Removal. Easy. Okay? Patrick, under the second case, Humphrey, how would the court, do you think, resolve this one, just under Humphrey? Could,
Probably looking to dysfunctions, whether executive or, as they said, quasi-legislative or.
okay. How would you characterize this independent prosecutor? Is it executive, judicial, legislative? Yes. She's a prosecutor. She's investigating crimes. That is the quintessential executive function, right? The Attorney General works for the governor. The Attorney General works for the president. The district attorney works for the mayor. You have the executive function. The prosecutor, Alexa Morrison, she was a purely executive official. So under both Myers and Humphrey, she's unconstitutional. Actually, this is one of the rare cases where someone argued their own case. So she actually argued on behalf of herself, which is kind of cool. She was the named defendant. She argued her own case to the court. So this is an easy case, right? 9-0. The independent counsel is unconstitutional. Wade, was the independent counsel unconstitutional?
It was not.
Why not? What did the court do? How the heck did Chief Justice Rehnquist, who himself had been the head of the Office of Legal Counsel, find a way to uphold this statute?
Kind of sound like Scalia saying that, but
You couldn't tell, huh? Yeah. So what did Rehnquist say? How does he square the circle?
he had said that the decision in Humphrey's executor was that it wasn't based solely on the fact that it was quasi-legislative and quasi-judicial. There is this inherent need for, like, was it good cause to be a standard, not something that can just be limited.
Okay. So if you take the charitable view, or let's start with the Scalia view, right? Scalia basically says they swept Myers and Humphrey to the dustbin of history, which is a beautiful image. And I think that's a fair characterization, right? Because we discussed this, and I think Juan and Patrick said it a minute ago. Myers said very clearly the president has absolute power to remove. Humphrey said, well, it's a strong power, but if it's quasi-legislative or quasi-judicial, the Senate can have a say in it. Here, when you have a purely executive official, Alexa Morrison, she's purely executive, that's it. This should be able to be removed by the president's discretion. But the court says, no, that's not the real test, right? That's not the real test. The real test, right, isn't based on what's executive or judicial. These are rigid categories, right? What's the real test? Here's the quote. I'll read it to you. Whether the removal restrictions are of such a nature that they impede the president's duty to perform his constitutional duty. Again, whether the removal restrictions are of such a nature that they impede the president's ability to perform his constitutional duty. Okay? So gone, long gone, is any discussion of an absolute power to remove. Long gone is any discussion of whether it's quasi-judicial or quasi-executive. The test here is whether this position gets in the way of the president's duties. Does this person get in the way of the president's duties? That's a short, long and short of it. So, Madison, does the court hold that this position gets in the way of the president's duties? Why not? Right. Why does it not get in his way? What about the independent counsel? What about Miss Alexa Morrison running around town and investing everyone for whatever? Why does the independent counsel not impede the president's duties? Okay, Daniel, what do you think? Why does this independent counsel not impede the president's duties? Anyone? Why is it that this independent counsel does not impede the president's duties? Oh, she's doing that. Do you think that helps or hurts him?
I think it says the appointment clause given to the Constitution, right? To have the power to appoint executive officials.
Mm-hmm, not exactly. I saw a couple other hands. Yeah.
Is it that the president still retains power whether to call this person into duty or not? They can decide. Like, he can't pick who it is, but he can pick when she's called.
Right. So basically, the court says there's some control, right? The attorney general can decide to call this person to play. He can't pick them, but they can remove them for good cause. So the court effectively, in the end, throws her hands up and says, well, the president can go about doing his job. She kind of operates on her own in her own little realm. And, you know, it's good enough. This is the good enough theory of constitutional law, right? There's enough check from the president that this is valid. In doing so, the court effectively explains away Meyer and Humphrey. And this is a question which someone asked me. Those cases remain good law. They remain good law. And in any question, you should be asking yourself, is this a purely executive or purely judicial function? Is this impeding the president's duties? And there's actually a discussion of a case, I'm not going to talk too much about it, called the public accounting, it's called Peekaboo, right? The public accounting, PAOCB, I always forget what it stands for. It's called Peekaboo. Free enterprise versus Peekaboo, where the Chief Justice walks through merging all those tests. So the long and short of it is you need to know all of them and think about them in any question about removal, which is not what the answer you want. But unfortunately, the court tangles this spider web together. Okay. Now, what does Justice Scalia write in his dissent, Ryan? What's Scalia's point in dissent?
Namely that he says that the system of separate and appointment powers like involves an acceptance of exclusive power.
Don't read, right here.
That can be abused. So he's basically saying that this, what I got, like allows, it doesn't let the executive branch abuse its powers.
What? Why do we have, Ryan, separation of powers? I mean, I've asked this question probably a dozen times this semester, but what's the purpose of the separation of the powers?
In order for each branch to check each other, so one doesn't like take over the power of the others.
What's the effect of this independent counsel? What's the effect of this independent counsel?
It checks the different branches of the government.
No. What does Scalia say? What does this independent counsel do? Scalia doesn't check the separation of powers. What does it do? No.
It makes executive checks itself, doesn't it?
Well, you're right, but the last point, does the independent counsel enforce separation of powers?
It's not.
What does it do?
It's just enforcing.
No. If it's not enforcing, what's it doing to the separation of powers?
Well, it's breaking.
It's violating the separation of powers. Exactly. The independent counsel violates separation of powers. Why, William, does the separation of powers violate? Why does the independent counsel violate the separation of powers? What about it? Who's giving away these executive powers? Who created the independent counsel? Who creates Congress? The answer is yes. The answer is always Congress. Congress is giving the executive power to this roving prosecutor who hovers in the ether, swooping down at a whim to investigate whatever he or she wants. Bill Clinton, Ken Starr, the independent counsel. I don't know if you know this, but the independent counsel with Ken Starr, which you maybe read the report or heard of it, it began as something very mundane about some receipts in the White House travel office and whether the White House people were not billing expenses correctly, and expanded to whether this guy named Vince Foster committed suicide or was murdered. And they expanded to this woman named Paula Jones who had accusations against sexual harassment. And then this involved some little intern named Monica Lewinsky, who apparently had sexual relations with the president. Right? So from a very mundane start, the independent counsel blew up into basically impeachment proceedings for the president over his perjury in front of a grand jury, lied to a grand jury. Right? What Scalia is saying is the Congress is giving away this executive power to someone who's not accountable to the executive. Now, I think William already said it, but Brett, shouldn't we be able to trust the president? Shouldn't we trust the president to like not break the law, or do we need this executive, this independent counsel to keep him in check?
There's already a check on the president.
What's that check?
The Constitution.
What's that check?
Impeachment.
Impeachment. This is Scalia's perhaps most important point. Our government, our system of free government is premised on trust. Anyone in government can abuse their office. Anyone. We have a President Nixon who abuses office very poorly. All right? We don't need these additional people who swim between the separation of powers to keep government honest. Because by doing so, we're putting too much power where it should not be. He cites the Massachusetts Constitution of 1780, authored by none other than John Adams, that says we are a government of laws and not of men. What does that mean, a government of laws, not of men? The same rules apply to everyone consistently. You cannot take away power the Constitution gives to the president because one president was a jerk. Right? You can't look at these principles and just wave them at will. And Scalia makes a point that I've said a number of times. The Bill of Rights doesn't mean a damn thing. Go look at bills of rights around the world, and they're worthless. What makes our Bill of Rights meaningful is you have the separation of powers to enforce them as a backstop. And once you start messing with those separation of powers, you go down a very, very dangerous slope. You have Ken Starr threatened to impeach the president because he lied in front of a grand jury about sex. Right? As a side note, the independent counsel statute expired. I think in 1997 it was not renewed, which was probably a good idea. Okay? And so Scalia says, this isn't really even a removal powers case. This is a separation of powers case. They've created this elaborate scheme with the Chief Justice and the judges and the Congress and the Attorney General and all these parties trying to shift power around to check a corrupt executive. Scalia says, this wolf comes the wolf. It's all unconstitutional, and the court's effectively ignoring Myers and Humphrey's executor. The court puts forward this balancing test. What's a balancing test? Does the president impede the ability of, is this law impeding the president's ability? What does this mean? We don't know. What kind of standard would maybe impede the president's ability too much? We don't know. The court doesn't say. And there hasn't really been a case on this since. So we're left with this standard where Congress can place limits on the removal power. How much, how little, we don't know, because the court left this issue wide open. Let the political process work itself out, says Scalia. They don't like it, impeach them. Don't mess up the separation of powers to get there. Okay, so questions on Morrison, sorry. Yes.
So does Scalia believe, like Olson did, that it was is that what?
Yeah, and I'll give you a funny side note about Ted Olson, if I have a second. Ted Olson was a prominent conservative lawyer. He was President Bush's Solicitor General. He argued all the Guantanamo cases. It was personal for him. His wife was actually named Barbara Olson. She was on the plane that crashed into the Pentagon. So he had a very personal stake in the Guantanamo cases. But in recent years, he's expanded his views, and he's actually one of the lead lawyers challenging gay marriage laws. So he's come somewhat full circle from a defender of the Bush's Guantanamo policies to a challenging gay marriage cases. He argued for the Supreme Court about 2 years ago. So a very interesting guy, Ted Olson. All right. Any other questions? All right, so for your class on Thursday, I assigned one of the articles I wrote. Make sure you read it. I usually try not to assign my own stuff, but this is such a novel topic, there's really nothing else written on it. So we'll be discussing the context of the president's duty to enforce the law, the context of immigration. So please read the article. I think you will learn a thing or two. All right, see you on Thursday.